everyone, and welcome to this week's episode of our Immigration Hero live stream series brought to you by immigrationquestion.com, your go to platform for up to date immigration insight, legal guidance, and real time conversations with licensed attorneys. My name is Anisya Mukherjee, and I will be your host today. Today, we're diving into the topic that's front and center for many highly skilled professionals seeking U.S. permanent residency, the EB-2 National Interest Waiver, or the NIW. If you're navigating this category, you already know that the landscape is changing. New updates to the USCIS Policy Manual issued in January 2025 are reshaping how petitions are reviewed and what evidence is favored. That's why today's session, EB2 NIW trends and the policy manual updates from January 2025, is both timely and essential. To help us understand what these changes mean in real terms, we're joined by attorney Ingrid Perez, founder of IBP Immigration Law. Attorney Perez immigrated to the US from Brazil at the age of 9, and her work has shaped both her legal experience and her personal understanding of the immigration journey. She holds a JD from Forham Law and is fluent in English, Spanish, and Portuguese. With a background in criminal defense and a deep commitment to advocacy, she brings a straightforward, compassionate approach to every case. Welcome with me, Attorney Perez. Welcome, Attorney Perez. We're so glad to have you on the show.
Thank you. I'm happy to be here.
All right, awesome. Let's jump right in. There's a lot to cover, and we know our audience is eager to get some clarity. So to start us off, how do the January 2025 policy manual updates impact the NIW process overall?
So that is a really great question. I think before getting into that, I think a little bit of background is really important to understand, the whole thing in context. So in January of 2022, there was, a push under the previous administration to facilitate immigration for STEM professionals. There was a lot of guidance, a lot of executive orders, and just a lot of, push from the administration for USCIS to help facilitate the immigration of these individuals, specifically focusing on those with STEM degrees. So what happened was after that announcement in 2022 in January, a lot of people started applying for EB-2 National Interest Waivers. And we're talking about people who normally would not be applying for EB-2s. So, people in IT, software engineers, those kinds of professionals that normally don't fit neatly within the EB-2 NIW. So in 2022, there's a huge number of petitioners. A lot of cases were getting approved. 2023, the numbers were still, relatively good. 2024, we start seeing some pushback on the part of USCIS. I think in mid 2024, we start seeing some requests for evidence that were sort of pushing the bounds of the NIW regulations and the way that the adjudicators are supposed to approach these cases. And we started seeing those trends. Lo and behold, January of 2025, there was a new policy manual guidance that really kind of clarified to, the people that were considering petitioning themselves for an EB-2 NIW, what USCIS was looking for, right, with these petitions. So a couple of things that stood out to me, at least. USCIS was clarifying, number one, that in order for you to meet the EB-2 classification, right, you have to have an advanced degree or exceptional ability. However, if you're going with, the degree, your endeavor and the work that you have to do or that you're proposing to do needs to be connected to your degree, right? They gave an example of, I think like a chemist, a person with a chemistry degree whose proposed endeavor was to, operate a bakery. That is very different than that person's degree. So there needs to be some degree of correlation there, right? Other things that USCIS was pointing out, at least that stood out to me, was that, your endeavor really needs to be concrete, right? And your ability to set forward that endeavor, to advance that endeavor also has to be concrete. And this was interesting to me because I was seeing some RFEs from people that were coming to me with requests for evidence where USCIS was challenging whether or not that person was well positioned to advance that endeavor. Now, I'll give you an example. I had one person come to me with an approved I-140 from another law firm. And that I-140 was then in the middle of being revoked. They received a notice saying that it was going to be revoked because they were having doubts that the person was well positioned to advance the endeavor. He had submitted a very ambitious business plan that talked about his plans for the United States. Mind you, the business was in his field, but this person was not an entrepreneur, right? USCIS was questioning whether or not this person really could come to the United States and make that endeavor happen, which was, unusual because I hadn't seen that kind of RFE before, so the policy manual really stood out to me in that sense. So, that was another change. Another sort of clarification that USCIS highlighted, right, was that people with STEM degrees, their endeavors still need to meet the national importance requirements of the, according to the Danassar case. So it's not enough to just have a STEM degree and be advancing your STEM occupation. They also highlight the difference between an occupation and an endeavor, right? And this is something, again, that I was seeing a lot in the RFEs, and, to no fault of the clients, USCIS was often mistaking the occupation to the person's endeavor, right? So for example, if you are, your occupational title is a mechanical engineer, and maybe you're working on research and development of some important technology, and that is your endeavor, USCIS was not really focusing on your endeavor, rather they were focusing on your occupational title. So the policy manual, in many ways, told petitioners to make a distinction between your endeavor, but still explain your occupation. But, still seeing a lot of requests for evidence that were conflating the two. So I think it's really important now for petitioners to be careful with that and really highlight the endeavor, making sure that the immigration officer that is reading the petition understands exactly what the endeavor is. So I think for me, those are sort of like the three biggest changes, right? Making the petitions, the adjudication standards just a lot tighter, and informing petitioners that everything needs to make sense, right? We're not going to just go with the fact that you're submitting, an entrepreneurial endeavor where you've never been an entrepreneur before. We're going to scrutinize that more. And for sure, I saw that in the, a lot of the RFEs that I was seeing from people coming to my office looking for help.
All right, that was really helpful. Now, let's talk about documentation. What type of evidence are you seeing USCIS favor in the NIW petitions right now?
So I've had a few petitions over the last few months be approved for people in the sciences, researchers. I had an agronomist and I had a vaccine researcher be approved. And these were people with, not a huge history of research under their belt, right? They had some professional experience. They were, the person who worked in vaccine research was fairly new to the profession, maybe was involved in a few research projects, but her endeavor was related to vaccine research and public health. She was approved with relatively little documentation of her research endeavor. Really, we focused on the national importance of her future plans and her work here in the United States. And for the agronomist, he had a history of research. And then he had, a long stint working in the field, more in like a practical profession in the world of agriculture. And then he was working at a research university supporting the research, and he wasn't even actually doing the research, but he was supporting the research. So I see that immigration is favoring petitions that has that component of research, right? So as much as I can, at least in my cases, I am highlighting how my client's endeavor really is informed by their research, how they will be advancing, knowledge in the field, how they will be still continuing to improve a certain method or, or whatever it is in their field, right? So immigration, I think, is really favoring that. Another aspect of EB-2 NIWs that I think USCIS is favoring a lot right now is showing that your endeavor is going to advance U.S. competitiveness, right? Part of the NIW is the national interest, right? What strategic benefit is your endeavor bringing to the United States? And not just for your field, right? But perhaps the strategic interest in staying ahead of the competition, right? How are our adversaries advancing, compared to us? And if your endeavor can help the United States stay ahead of the curve, that is a good argument as well for an NIW.
Thank you for that. Let's talk about outcomes. Based on what you're seeing this year, are there any noticeable trends in EB2 NIW approvals or denials?
I think there are definitely some trends, and I have definitely seen them in my office. I think that USCIS is pushing the boundary quite a bit when it comes to EB-2 national interest adjudication. I've seen situations where they are creating more requirements than really are necessary. So I think it's important for practitioners and self-petitioners alike to push back on that and not give USCIS any rope, because if we give them rope and the ability to sort of create new standards, we're going to be inadvertently creating a new standard for them, making it harder for our clients. So I think, it's very important to stick to the minimum requirements of the criteria, right? And not fall victim to thinking that we have to prove more than what we have to. So I have seen that in denials where USCIS is denying because the person has not met every single one of the bullet points that they are looking for. And I tell people, and I remind USCIS that a lot of the information or the things that the clients have to prove, it's not an and, but it's an or, right? So USCIS does not have to consider everything. The client does not have to submit proof of everything. A lot of times it's a choice because not everything is applicable to everyone. So it's very important for us to make sure that USCIS is following their own guidelines and their own standards.
Thank you. For those currently preparing or planning to file, how can they make their qualifications stand out in the current guidelines?
That's a great question. I think that the most important thing for a person to consider is the audience, right? We have to sort of imagine the human reading that petition and what they must be going through, what they must be thinking, right? Number one, you have to always assume that the person reading your petition knows nothing about your field, knows nothing about your work or what you intend to do. So I think here simplicity is key. Explaining the endeavor in very simple terms, sticking to exactly what you want to get across, not getting into the weeds of too much, right? And confusing the immigration officer, and being consistent throughout. I think that's very, very important in any petition. Another thing that I like to do in my cases is really tell a story, right? Again, going back to thinking about who the immigration officer is. They are reading dozens of these cases a day. They may be tired by the time they get to yours, right? So I think telling a compelling story, telling a story that is, interesting and that makes sense is very important. And I would also encourage people to edit their petition, because not everything a person submits may be helpful in the petition. So in my practice, I'm trying to be a little bit leaner as well, and just really ensure that the immigration officer is focusing on those things that I want them to focus on. It's not a good approach to just throw everything in the kitchen sink in a petition, because you really want it to be lean. I see these RFEs and denials. People come to me with these long denials or these long RFEs where the officer seems confused, right? So as much as possible, I think that petitioners and attorneys alike should streamline their cases and make it very simple and easy to digest.
Thank you for the insight. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management software to help simplify the immigration process. You can ask your immigration questions for free in any language and get connected with a verified attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. Now, Attorney Perez, as a platform that connects documented and undocumented immigrants with trusted attorneys like yourself, what are your thoughts on how immigrationquestion.com supports the immigrant community today?
I think this is a great way to support the immigrant community. I know that immigrants go online to ask questions. They're looking on YouTube, they're looking on social media, Reddit, friends, family. So having a platform, where you're getting your questions answered by an actual verified attorney is great.
Just one final question before we go into the Q&A. What's one piece of advice you'd give to someone considering an NIW petition in this new environment?
Well, one piece of advice that I would consider is that, hope for the best, but don't count on it because NIWs are discretionary. They are still discretionary benefits. Of course, as attorneys, we can never ethically guarantee that USCIS will approve a case. I know based on experience what cases have a better chance of being approved versus others, right? I tell people no all the time. And I think, if a person is willing to still try, that is totally fine. But I think that as long as you approach this process knowing that it is a discretionary benefit, then I think you can go ahead and seek the benefit that you're seeking. Unfortunately, in today's climate, these cases are harder, right? They are harder. So you have to think about it in terms of, I think, is it a good investment of time and money on my part right now? What deadlines am I facing that warrants me going for this right now? And how much effort are you willing to put in it? Because an EB-2 NIW is definitely a collaborative process between you and your attorney.
Thank you. That was amazing. To our audience, the floor is now open. Drop your questions in the chat and we'll answer as many as possible. If you'd like to call us live and ask directly, dial 516-703-3483. And we already have a question. If I get denied for INW, can I reapply immediately or do I have to wait for a certain time?
I think this really depends. I mean, there's nothing in the law that says you can't apply the very next day, but I think you have to start by looking at the reasons for the denial, right? Was the reason for the denial something that you can cure relatively easy? If it's something that you can cure, then, you can consider applying it the very next day, right? But if it's a deficiency in your case that, you just simply could not meet a certain prong, or it's something that may require more time for you to sort of, work on and develop, then you may want to consider whether or not waiting some time makes sense, right? It is important to know that USCIS is always going to have access to your prior petitions, and you want, case number one to be relatively consistent with case number two, right? So it's I think you have to take all those things into account, but there's nothing that keeps you from applying the very next day.
Thank you. The next question is there a difference in how many they will treat STEM or non-STEM applicants under the NIW rules?
So STEM applicants, there are special considerations that USCIS will make for STEM applicants. For example, if you are a professional in STEM and you are advancing an important technology that is, important to the United States, they will consider that in your favor, right? And that is something, if you're doing that, you definitely want to use a policy manual to your advantage, and you want to use all those wonderful footnotes and everything that's in those footnotes to your advantage. Print the policy manual, read those footnotes, click all of those links, because there's just a gold mine of information that you can use to your advantage in a STEM endeavor.
Thank you. Next question is, I have a startup that just got pre-seed funding. We're still early. Is it too soon to apply under NIW?
It depends. Contact me.
Perfect. Next question is, I have a bachelor's degree and 6 years of experience. Do I need to show how each year relates to my field to get an NIW?
So generally, yes, because if you're qualifying for the EB-2 classification through the equivalent of an advanced degree, which is a bachelor's plus 5 years of experience, that experience needs to be progressive experience post-bachelor degree and related to your field. So yes, you do need to show that.
All right. The next question is, does USCIS only care about nationwide reach for NIW, or can something small but helpful in one state still qualify?
Something small but helpful in one state can absolutely still qualify. There is no geographical requirements for an NIW. What is, important to consider is whether or not there's an important strategic interest that your endeavor will advance, right? So the nationwide reach was more, was something that they looked at under the New York State Department of Transportation case that was before the Danosar case. So in order to make those cases easier for the adjudicators, we have matter of Danosar. So I'll give you an example, right? I have a client who develops affordable housing in the state of Florida, in one county of Florida, right? His endeavor is limited to that county, but the importance of affordable housing is nationwide. So even though the benefit he's bringing about is only to that specific county, the United States has an important interest in ensuring that we have a supply of affordable housing for Americans. So you see how, even if your endeavor is focused in a small geographical area, it's still helping to advance an important national interest.
All right. Another question from YouTube is, just to clarify, does the professional experience need to be US based, or can experience from my home country count as well?
You can definitely use experience from your home country. That is absolutely acceptable. You can apply for EB-2 NIW from outside of the United States without ever having stepping foot inside of the United States.
Perfect. Will letters from local government officials help in my NIW application, or they have to be from the federal agencies?
So there is an update in the policy manual as well that talks about the interest in your endeavor and by quasi-government agencies or government agencies. I think that local government officials can definitely help a petition. It doesn't have to be from a federal agency at all.
All right. I think that was our last question. That was an excellent way to end the session. Thank you so much for joining us, and a special thank you to our special guest, Attorney Ingrid Perez, for your practical and strategic insight. We hope this webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our site to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again Friday for another interesting topic. Trust us, you won't want to miss it. Once again, thank you, Attorney Perez, and we look forward to having you back soon.
Thank you for having me. This is great.